Good afternoon, good morning, depending where you are in the world or evening. Welcome. We're about to start the webinar on football players' transfers. Should FIFA be allowed to have special rules beyond domestic contract law? We're going to give people a couple of minutes just to log in. No doubt some of you have probably done this before, but many of you won't have. So we'll just give people a couple of minutes to do that. Whilst we do that, we'll go through some just introductory points. First of all, who am I? So I'm the CEO and founder of LawInSport. My name's Sean Cottrell. My role today is to facilitate discussion between our fantastic speakers that we have for you and to facilitate questions and answers, but I'll come onto the format shortly. So, introducing our speakers, hopefully you would have already seen from the website and the announcements that went out who our speakers are, but just in case, to give some perspective, we have Professor Stephen Ross, who's a director of Penn State Institute for Sports Law Policy and Research at Penn State University. He's got an extensive experience and an incredible background in law, looking particularly at areas of sports law and comparative constitutional law. He's been an attorney at the Federal Trade Commission and the US Department of Justice. He is also an expert witness, particularly on antitrust matters, or for those who are not so in the US market, but more competition law, as we refer to them over in Europe, at least. And he's also a senior fellow at the American Antitrust Institute, as well as publishing various books and papers over his time. Stephen, thank you for taking the time to join. I know that you're traveling around the US at the moment, so I really appreciate you, taking the time to do this. Next up, we have Daniel Geey. He is a partner and now a renowned author, let's say, of the book Done Deal. He's a partner at the law firm Sheridans in their sports, media, and esports team. Daniel is a go-to lawyer on football law matters. In particular, he built up a profile and expertise looking initially at financial fair play, but then on acquisition of football clubs and fit and proper persons test, parachute payments, image rights, player contracts, and a whole bunch of other different areas. Many of you will follow him on Twitter and know that he's just a fantastic bridge between what's going on in sports law and most of the people working in football. Daniel, thank you for taking the time to be on the podcast. Well, say podcast, sorry, the webinar.
Pleasure, and thanks for getting us involved.
Yes, right. And I'll do. Yeah, I said if you haven't checked out his book Done Deal, it does provide a fantastic insight into the business of football. So check that out. Then next up we have, and so for background, so Stephen's based in the US. We have Daniel from the UK, and then Ricardo Oliveras, who is the head of sport and a corporate partner at ECIJA law firm in Spain. He started his career at KPMG Abogados. He worked as a lawyer on the America's Cup management in 2004-2007, Super League Formula Motor Series from 2008-2011. He was a legal advisor for Spain in the selection process to host the World Cup in 2018. He's also heavily involved in academia, and he's a professor at different places, visiting lecturer, sorry, at a bunch of different places, but including running the program for and involved in ISDE, which many of you will know as one of the leading sports law education providers. So Ricardo, thank you for joining.
Thank you. It's a pleasure to be here.
So for background, just in case you're not familiar with LawInSport, we're a knowledge hub and global community. We essentially help people understand the latest legal issues and developments from the world of sport. As a basic principle, everyone should be able to understand the rules and regulations that govern their behavior. These webinar series we're doing at the moment, we did one this morning on legal issues in African football, are there to try and help to create some dialogue, some opportunity for you to ask questions and explore some of the developing areas within, well, in this case, football, but also in broader sports law. The format of the discussion today is going to be the speakers are going to have some time to discuss and present their perspective on the question that we've posed, and which was actually sparked by Stephen. So thanks, Stephen, for this. He was a driver of this at the sports that we had a conversation, I think, a couple of years ago now, at the Sports Lawyers Association conference, and so his area of interest and research has sparked this. So thanks for that. And then we are throughout the discussion. Please feel free to ask questions. You can either do it by raising your hand. So there is a function in your control panel. Hopefully, if you can see a control panel, you can raise your hand at any point if you have questions. And so I can see Timoteo. I'm probably saying that wrong. Timoteo. There we go. Has already raised his hand or her hand, sorry, for a question. I'll come to you. We'll let the speakers start first. You can also write questions. So thank you, Shane, saying that you're looking forward to the discussion. So are we. So you can engage with us that way. I'll keep an eye on that. Hopefully we'll get time to answer everyone's questions. We did run out of time this morning, but we got to most of them. So without any further ado, I think that's a very short 5-minute introduction. Hopefully you all know now how to ask questions. You know what we're going to be, how it's going to be structured. Sorry, I'm just getting the next slide up. If I can get it to work. There we go. Right. So to start off with, the main question that we had was, should FIFA be allowed to impose special rules beyond domestic contract law with relation to player contracts? Throughout the discussion, we will explore this, and we can then maybe come at the end, look at, if so, to what extent should they be permitted and what remedies should they include. Hopefully we'll touch on things like the roles of agents, cultural impact on how football players and clubs consider player contracts and approach them, and how that impacts domestic jurisprudence and approaches, and then what protection players have when they are injured. We'll see if we get there. We may not have time because of other questions. But to start us off, Stephen, obviously you were the catalyst for this webinar taking place, so thank you for that. Would you like to start off to sort of bring your perspective and your research, and particularly the US approach to player contracts, and how you think that differs to what happens in football, particularly European football?
Sure. Thank you for having me. This is a very important area of my own research, and I do this with some temerity as an American, commenting with a distinguished group of panelists, and also fundamentally disagreeing with someone who is perhaps the leading English sports law academic, Professor Stephen Wetherill from Oxford. Professor Wetherill argues that it is a breach of free movement principles for any private parties to agree on contract remedies that go beyond domestic contract law. Moreover, he argues that there is no justification for treating professional athletes like any other workers. I have a different perspective. The United States follows the traditional English rules of equity, which the English courts have actually moved away from, that say that when an employee has skills that are very difficult to replace, that where damages cannot be adequately computed under law, where the employer has acted with equity, and where the balance of hardships tips in favor of the club, that you can restrain a player from going to another club. That is not permitted by virtually any European contract law doctrine. On the other hand, the current FIFA rules on the status and transfer of players is far too broad, in my judgment. It basically gives the extraordinary remedy of equity to every club for every player, no matter how ordinary the player is, no matter how easy it would be to replace the player, and no matter how easy it would be to compute actual damages. Returning to Professor Wetherill's concerns, my first argument is that there is a particular European interest in uniformity in labor markets. Belgium protects has virtually no protection for a club. And the idea that Chelsea could poach a player from Anderlecht and pay no damages, but when Anderlecht wanted to poach the player who was now benched by Chelsea, they would face multiple damages under English law, is not a sustainable position for a European labor market. Secondly, the argument is that the wide variance in expected performance when a football player signs a contract justifies the special treatment of them. When I'm paid a salary, whether I'm on a contract or not, what Penn State is going to get in terms of my value is pretty narrowly, they know what they're going to get in the next 4 years from me. But when Tottenham Hotspur signed Roberto Soldado from Valencia, I believe, they thought they could potentially be getting a big star, and he was a complete failure in the English Premier League. And it's that particular risk that strikes me as justifying special rules. In some, where I'm sort of coming out and would love to hear the views of the other panelists and the audience, is that the traditional English rules of equity ought to be the rules that FIFA should adopt, that a club can restrain a player from going to another team where they show the player is very difficult to replace, where they show the contract has been signed equitably, the player was well counseled, had a good agent, etc., and where it is not easy to figure out the damages that the club would suffer because a star player has left them. I look forward to everybody else's comments.
Right. Okay. Thank you for that. So there was three points there, but so Daniel, would you like to start, or Ricardo in response to that?
Yeah, I'm happy to start. It may actually be that, Steve, and then we can start a little discussion, because my view there, and obviously what we discussed yesterday in part, is that at least in terms of my experience in the UK and England, we are closer to the secondary element of what you said in terms of restraining a player's ability to be able to leave their contract, and the potential damages and compensation that may be payable by the player if they do such a thing, dependent on a variety of FIFA rules if they're outside or inside of their protected period, etc., and particular CAS jurisprudence, Methuselah, Diarra, and others in terms of compensation payable for reputed breaches of contract. But I think ultimately what at least I see from my side is, if a player is sacked by a club, the risk that a player faces still is that the club can potentially sue that player for the non-amortized portion of his transfer fee, potentially then the replacement value of a player, and the associated costs that come with that. And in some of the matters that I've dealt with, that's a real concern from the player. Now, you saw with Mutu and others, even though potentially Chelsea haven't so far received, in my understanding, haven't received any of that money after they sacked Mutu, the risk still significantly impacts on players that want to move or want to consider moving, simply because they have an underlying employment contract. So it's the longest question of all time, which maybe is back to Stephen, is saying, at present, my understanding at least is that we are closer along on the spectrum to what you believe the situation currently is, at least in the UK, with a decent type of contractual stability, yet at the same time, unless there is either one, a consensual transfer agreement made between two clubs wanting to transfer that registration, or the player is out of contract, as we spoke about yesterday as well, then it's not particularly easy for a player to move from club to club, bearing in mind your national variances.
Yeah, so Ricardo, I'm not sure if you want to add something first, and then Stephen, you can pick up on that.
Yeah, absolutely. Yeah, Stephen mentioned that basically, from his point of view, or his colleagues, the FIFA rules sometimes are too broad. But I think we should take into consideration that FIFA is ruling, the football industry has an international dimension. So sometimes FIFA has to decide on matters which is involving players from one country or one continent to clubs from the other continent. So I think we should understand, and we do accept already, most of the professionals that were involved in the sports industry, that there is this specific character of FIFA of this international dimension. I think that at some point of time, FIFA, I mean, if you compare FIFA regulations with domestic regulations, the FIFA regulations has been amended a lot of times during the past years. I mean, we have just had a recent new rules on status and transfer of player in force from 1 month ago. So this is quite characteristic, because in other jurisdictions, even in Spain, it's quite complicated to amend the labor law or other civil law. So FIFA, my point of view is that since the Bosman case with the European Union, since they tried to adapt their regulations to the European Union policy, and as Daniel said, due to the jurisprudence of CAS, they are now trying to adapt and follow the jurisprudence of CAS in the new regulations. So I think that, at my point of view, I would say that, yes, they should be allowed to have some rules beyond domestic, although domestic regulations also have to be quite protected to the football player who's playing in that country.
So Stephen, would you like to like to go back?
If I could go back on very good points that both Daniel and Ricardo made. First, Daniel, I think we need to distinguish between the very important issue that you address and actually sort of the one I was addressing, which is I'm addressing the issue of when a player is in breach. The player has done nothing to justify a sacking. The player has not done anything like that, but simply wishes to move to another club. And when I think about it, I think of three scenarios. One scenario is a player on a second-tier team in a Central European league, signed perhaps out of a developing country, who is not being paid. In the United States, this player would become a free agent based on an arbitral ruling in about 30 days. The process, because of the FIFA rules that give a unilateral property right to the club and put the burden on the player, is much longer and is rife for abuse. The second situation is a player who has been benched, is out of favor, is of no significant value to a team, and wants to move to a team where perhaps they can find better success. That player effectively takes a huge risk right now, and a new club would take a huge risk right now of signing that player and then going through the Article 17 process. Instead of, whereas under certainly domestic law and other law, the club would not be able to prevent that player from leaving, because the club simply could not show that this benched player's loss or the breach would cause the team any irreparable harm. And then the third example, which I confess started my whole research here, is when Gareth Bale is playing for Tottenham Hotspur. They are scraping to get into the top four and compete with the traditionally four dominant teams in the English Premier League. And Real Madrid announces they want Gareth Bale, and so Gareth Bale goes off there. I've spoken to a number of Tottenham executives who said that they would have preferred Gareth Bale to the £100 million they eventually received in a fee. And that strikes me as an example of an athlete who is very difficult to replace, and where traditional principles of equity would say that they should not be allowed to go to rival teams. There's a strong tradition throughout, well, everywhere, that people have a human right to work in their chosen profession. But Gareth Bale does not have a human right to work for Real Madrid. And if he really wants to work in his chosen profession, in breach of his contractual obligations to Tottenham Hotspur, there would, under my proposal, there would be, the injunction would not apply if he wished to play in a second-tier team in France. He could still earn his living, not anywhere near as much as he could earn under his contract, but that is part of the deal he made. So, so I think those are the issues that I'm talking about, and figuring out a way to allow clubs to continue to offer players significant amount of money guaranteed for a 4 to 5 year contract, even if the player does not perform. And my argument is that players, that clubs will stop offering major multi-year contracts if a player were free to leave at the end of every season without paying significant damages to the club.
Did you want to take that in terms of?
Sure. Well, yeah, there's a few things there. I understand the point, Stephen, and I think if what we are effectively saying, maybe I'll let Ricardo deal with the non-payment point, because that's certainly a FIFA regulations point that I know you have lots of experience at dealing with, Ricardo. But if I was just to take the rail to bail, bail to rail point, without confusing things, my view on transfers generally, and based on my experience of assisting on quite a few, is that ultimately, if a club does not want to sell their player, and sell is sometimes the wrong word, I think, really. If a club is willing to receive a particular level of compensation in order to rescind the contract, I guess, and then effectively transfer his registration, then that is the club's prerogative. Now, I know that there are always going to be issues around player power, around a player not fulfilling his potential, doing his potentially best if a team, if his club decided not to sell him. But ultimately, Spurs in that example, and I wasn't involved in the transfer, made a cost-benefit analysis decision based on the fact that a huge amount of money was on offer, and that Gareth Bale presumably wanted to leave for that club. So, whilst I do have sympathy with plenty of clubs that aren't in the strongest bargaining position when an elite club comes for their player, ultimately it is still at the behest of that club to refuse. Now, the actual question, which I think is a really fundamentally interesting one, Stephen, that I think is very much the heart of your question or summation, is what happens, or what could a player do if they took the club to court for refusing to allow a transfer to occur if that player is under contract and under the same type of employment law restrictions or employment law conditions as a normal type of employee generally. And I think so far, at least I haven't seen anything to the contrary. At least so far, this idea of specificity of sport takes us some way. The CAS jurisprudence on what would necessarily be deemed replacement value takes us some way. But ultimately, I haven't seen, and I'm maybe to be corrected by lots of people on the not the podcast, but on the webinar that we're doing, is a situation where a player has actually taken a club to court for refusing to articulate or allow a transfer to happen. Stephen, you're exactly right in what you say in terms of Article 17. That obviously, as you know, is a pretty narrow window for a player to be able to activate, and is fraught with difficulty. So ultimately, unless a consensual approach is usually given or is made between two clubs as parties, it becomes a pretty difficult bargain to be made otherwise.
So, but isn't this where you'd like to think that when someone's negotiating their contract, they could obviously introduce a buyout clause, which would envisage such scenario. So in a scenario where they've got good advisors, this would be played out anyway, which is more commonplace nowadays. So it would be seen that a Real Madrid would come, and that would be fine, and it'd agree that for the development of the player and for their best interest, that they will be able to go should they want to. Right, because likewise it would be free. Tottenham would be free to obviously increase the salary if they wanted to. What I'd be interested in, and Ricardo, I don't know if you want to add anything beforehand, but Stephen, I'd be really interested to see how this compares to, say, for example, with is it Anthony Davis moving to the Lakers, and how that plays out in something like the NBA.
Well, if I could just ask Ricardo perhaps to talk a bit about buyout clauses under Spanish law, because my understanding is that buyout clauses are permitted, but not if abusive, or I can't remember what the term is, but
Yeah,
the Spanish courts will review a buyout clause and not automatically enforce whatever the parties had negotiated. And I think it's important to have clarity, and I don't know how much Ricardo thinks the Spanish law is clear, as to what sort of buyout clauses will be enforced and what sort of buyout clauses will not be enforced either by a Spanish labor court or by a CAS panel.
Yes, as you said, Stephen, our Spanish system already provides under the labor law for sportsmen the right to include a buyout clause in the contracts of professional athletes, professional sportsmen, football players. Indeed, all of the football players' contracts under Spanish law, it is a provision for the buyout clause. What is fact is that this buyout, the rationale behind this buyout clause is the right of freedom for the football players to terminate a contract and to go to another club. Obviously, with this buyout clause, they can come and compensate his current club. However, as you said, this has been now it's changing. For the last years, it's changing due to the jurisprudence of our Spanish courts. But at the very beginning, what happened is there was an abuse on the amount of this buyout clause. For example, a club playing in Liga, with a football player quite young, that his salary was not even maybe 100,000 euros per season, and they agreed it by contract a buyout clause of 40 million euros, okay, for a salary of 100,000 euros. So what happened, some cases happened, and then some players took this clause to the court, saying, just trying to the judge to moderate the amount of the buyout clause, because according to our system, the buyout clause, it's like a penalty clause, and the judge has the right to moderate the amount of this penalty clause if it considers that it's abusive. So far nowadays, from my experience, when we are advising our clients, either agents or players who are signing a buyout clause with a football club, we always try to make them to understand that this buyout clause it will be necessary to have some sense related to the salary of the player. Obviously, the market is very important as well. So sometimes you could include a buyout clause for a fee, for an amount which is quite high, but if it's accepted in the market, because he's a forward or a very good defender, you will not have problem at all. But yes, this is in our system, and I think it works quite well. It works quite well, both for the club and for the player. Because just to finalize, I think here that there is a cultural matter, at least from my perspective in Spain, with American athletes. American athletes, I'm not familiar with and don't have experience, and just what I'm reading or I see on TV, my feeling is that American athletes, when they are playing for a club, football, basketball, soccer, whatever, they do understand they do belong to the club. They are an asset to the club. In our Spanish football, that's quite different. I mean, football players sometimes, and we will talk about the role of the agents, sometimes they are just there for a period of time, and they are thinking, okay, I'm going to stay here for a couple of 2 or 3 seasons, then I will move to another club. So this feeling of property to belong to a club, I don't know in UK, is not so inside as they may be in USA.
So I think, thank you, Ricardo. To me, I guess I'd make a procedural and a substantive point. Procedurally, I think it's critically important for the law, whether it's a caste jurisprudence or domestic law, to be clear. Because when law is uncertain, I think you're going to have it's going to be much more difficult, and the end result will be often that a player will have to face a much higher transfer fee, and the resulting be a much lower salary for himself if the law is unclear and the parties don't want to take a chance on litigation. Okay. Both within the area of buyout clauses under Spanish law and the traditional term of liquidated damages under the English common law, what makes sports a unique issue is the potential variance of the damages at the time the contract was signed. Typically, a buyout clause or a liquidated damages clause is supposed to be a reasonable estimate of damage. But again, to use the example, since I support Tottenham Hotspur, the potential, if you think
I think 50 people just signed off.
If you look at what Tottenham Hotspur expected to be damaged by Roberto Soldado, it would have been extremely high. If you look at the actual damages from if he were to have breached, it was extremely low. And what the courts are not specific on enough, in my opinion, because it hasn't really arisen in sports, is suppose you sign a contract with a young player, and it is possible that the damages will be zero. It is also possible that this player will be one of the greatest stars ever. I'll use an American example that some of your listeners may be familiar with, Stephen Curry of the Golden State Warriors. He was injured after his second year, and he signed a 4-year contract for $11 million a year to play for the Warriors. There was a distinct chance that the damages would be zero because he would not really come back from his injury and wouldn't be able to play at all. By the end of the second year, he was the second best player in the National Basketball Association. He was clearly worth well over $40 million a year to the club. So the question is, under that circumstance, would a buyout clause that would reflect the upside, would that be enforced under Spanish law or as a legitimate liquidated damages clause under English law when a reasonable estimate of damages is completely unknown at the time that the contract was signed?
If I can, maybe just mention one practical point there, and I completely agree with it on the, again, practical side, which is when we're talking about release clauses or buyout clauses in an English and UK context, Stephen, I completely agree with everything you said in terms of, reasonable pre-estimate of loss, in terms of the release clause not effectively becoming a penalty clause, which is effectively unenforceable in English law. The practicalities of it ultimately is, that there is risk and reward for a player when, in the UK sense, a release clause is negotiated to a degree, because everyone will sometimes say, and it was rumored that particular clauses might have been put in certain contracts, a variety of players, but ultimately a release clause is seen to be in the UK as a benefit to the player, i.e. it's something that the player's agent will try and include so that if the player is successful, hopefully the amount isn't large enough to disincentivize particular and potential buying clubs from activating that particular clause. Now, that hopefully should be at the lower end of the market value, because that will be the incentive to be able for then a buying club to do that. But to the detriment then usually is that, and I've seen it plenty of times, is that then the club at the time, his employer, will then say, well, that's fine, but that's a significant benefit to you, the player. And as a result of us losing some control over your ability to transfer, then we are not either paying you as much because this is a significant benefit. We're not remunerating you as much as you otherwise would have been, because if a bid comes in and you are playing well, we have no ability to be able to control as a result, and that can be a very important element of it. And the playoff sometimes can be is that the player will say, to be fair, I would rather have the security, even if it's short to medium term, of a larger wage, salary, signing on fee, loyalty bonuses, image rights structures, etc., and not have the buyout clause and release clause, rather than the benefit of a release clause. And even if there is the release clause there, there's usually a huge amount of negotiation over what that amount will be. And Stephen, I completely agree, which is, what is that reasonable pre-estimate of loss? Is it crystallized at the time when the negotiation happens, or is it a dynamic figure which changes as the length of that contract goes on, and whether the player is more successful or less successful accordingly?
Well, I wonder though, 'cause say for example, you're setting up an image rights company, right? There's a bunch of assessments that are done as to the value of particularly young players at that moment in time to pay the capital gains tax. So I'd wonder if there would be enough data now, because there's a question of data. There's more data in the market that you could get a more, say, at least average indicator that it could be anchored to, as you were saying, with more fluid figure. We've got a bunch of questions, and so sticking to that point, like they've been coming in thick and fast. So so apologise if these jump back a bit, because I mean I'm just trying to invest it. So it says Shane Wafer, for Professor Ross, what impact does a breakdown in player-club relationship have on your views of restraining a player? If a player is invaluable and a club cannot afford to lose them, and the contract is sound, etc., but the player cannot play until a coach due to personal circumstances, for example, could you still restrain him if you're applying rules of equity? Is it similar to restraint of trade?
Well, my approach would be that if the burden is placed on the club, where I think it should be, to enforce a special relief other than the player goes and you sort out damages later. If a player is not playing because of a breakdown in the relationship with his coach, I think it's going to be very difficult for the club to show that the club will be irreparably harmed if the player breaches the contract. And under those circumstances, I would think that modified FIFA rules would permit the player to leave, and there might be hopefully a relatively quick arbitration proceeding that would be allowed to establish the damages if the second club couldn't reach a very quick agreement with the first club on what the transfer fee would be. So I think if we're talking about the club is benching a player, and let me use the alternative situation where the player is refusing to play and causing a lot of problems with the club. Then you first get into the situation that Daniel first addressed, which is whether the player is in breach of contract and whether and what remedies there might be. And then the other, and in that case, the player does, if he were playing, would have great value to the club. I would say that the club should have this property right and should have the right to release the player or not. And then it's a matter of negotiation. And as Daniel and Sean said at the beginning, then it's up to the club to assess, do they really want to keep the player or not.
And so Daniel, or Ricardo, did you want to talk about sporting just cause just on that point, and the provisions around that? Because there's a bunch of case law around that about when players are frozen out, etc. And I think there's some updates around this in terms of things like non-payment of football players and stuff like that after 2 months and etc. There's some recent changes, I think, to kind of address this point where I think it's something that FIFA Pro and the player associations have been working quite hard at, actually, when players are frozen out for non-sporting reasons, just because they're out of favour. Would one of you like to take that, or should I move on to the next question?
Well, as you said, I mean, the FIFA approach has been, I mean, year after year has been more protective to players. The role of FIFA Pro has been very, very important on this. And nowadays, I mean, if there's some outstanding salaries, we know that with football players, and now FIFA provides the protection for the football player to terminate the contract. Although, and here is a very important domestic point, domestic matter to be into consideration, FIFA sets the minimum period of 2 months. However, it depends on the collective bargaining agreement in each country, where this minimum period of 2 months could be 3 months or 4 months. So I think that's a very good approach for FIFA, because FIFA just set the minimum. They did not impose that rule. So I think they were quite clever on this.
That's a very good point. Daniel, did you want to add anything?
Yeah, just a brief one, which the flip side is also the case, is that there are domestic footballing regulations. So, for example, the EFL or the Premier League, the EFL will potentially impose sanctions on the club in addition to a player's remedies in order to disincentivize non-payment. So there are instances at the moment in English football where clubs are under transfer embargo, reported to be on transfer embargo, because they haven't paid player wages, etc.
Yeah.
So again, this is almost the additional, exactly as Ricardo said, over what the minimum requirements are to incentivize best practice and behavior.
And it would seem to me that there's that there's been a real shift, and that people talk about stakeholder engagement and about how much, whether the clubs or how much power is each constituent can't say it member has in that process. But it would seem to me that I think there's a wide consensus that this needs to be improved globally to improve the standards of football, to improve its investability, and it is taking place, but at different rates internationally. Right, next up we have Cambyse Heron, who, hi Cambyse, regarding international dimension of football, domestic contract labor law varies across jurisdictions. You might just answer this question actually. Can FIFA impose special rules not to provide a minimum level of global harmonization, which may lead to a more level playing field between rivals continentally? I think it's a good point, and I think Ricardo, you started to touch on it then. Did anyone want to take that? Because I think that's one of the differences, particularly if you look at the major league sports in America. Obviously, you've got the cross-state issues around tax and some other things like that, but you've got that, on the continent, or at least in the country, so I should say, you've got coherent rules and approaches. Whereas in football, you've got what's going on in South America, what's going on in Africa, Asia, etc., is different to what's going on in Europe.
Well, the U.S. actually has a stronger approach than Europe, I think, reflecting the more centralized nature of the United States. Individual state employment law cannot be applied in a sporting context where a court finds that the rules must be uniform, and they can't be applied. So if, for example, a state employment law in California would allow someone on the Golden State Warriors more rights than someone in Illinois playing for the Chicago Bulls, that law is not applicable. Where there is no need for uniformity, state laws could apply. So, for example, to use one example I use in class, there is no rule in the National Football League about what kind of turf you can use on a field. And if California were to outlaw artificial turf because of safety issues, that would be permitted because there is no uniform rule. But if the National Football League had a rule that said everybody's got to play on artificial turf, then California could not impose its own rules on that. And if people wanted to, they would have to turn to Congress, the federal government, for that purpose. And I appreciate the European scheme is a bit different in that regard. So the issue is whether, because member states can impose their own non-uniform rules, it is permissible for a private organization, FIFA or UEFA, to impose uniform rules so that the rules are treated the same. And that's one of the issues that I'm researching, and as an American, I support the idea of uniformity.
Does anyone else want to take that, or shall I go on to the next question? Does anyone else have anything to add? I'll take that as a no.
It's quite tricky. I mean, I would like just to say, from a European perspective or national perspective, that, I mean, it is not the fact that FIFA impose the rules to national laws. It's basically that, FIFA is a private entity, and the football industry in the European Union, at least, is under the control of non-profit private entities. So basically, it happens also with all of the sports when like the IOC also they ask to their national members to abide to the status of the IOC. Same happens with FIFA. I mean, they follow I would say that the model, the pyramid model that we do have in Europe with IOC, international sports federation, national sports federations, is quite different from the US perspective. And it's a model which they protect themselves always under the argument that doing that they avoid to suffer about discriminatory religious politic matters. So they want to keep sport aside politics. So they can apply these principles of uniformity because it's under a private system. It's a private, but so in some cases, at least in Spain, some football clubs, they have tried, they've been against decisions taken by the Football Spanish Federation, and they try to take the Spanish Football Federation to the courts. But when this happens, obviously, FIFA reacts, the Spanish football reacts, and if you want to play, to be a member, to be part of this, well, you have to follow the rules on this private system. I don't know if I'm clear on this point, but it's quite tricky.
It is very tricky. I think it's going to be really interesting to see how that develops when more private money comes into, as the alleged approach is for private investment into certain international federations. I think that will start to sort of maybe influence that. The next question we've got, and this is actually to you, Ricardo. So Daniel, did you want to add anything to that?
No, it's good. I'm keen to get through some good questions as well, really, and I think those guys were correct.
Thanks, Daniel. So Marta Utor has said buyout clauses in the case of youth sportsmen is a very difficult issue, and Spanish clubs have now started to audit all of their expenses they have with regards to the education of their players. And there is surprise, even though people in courts could consider that 400,000 is a good big amount, certain Spanish clubs do spend more than 100K per year per player educating, accommodation, training. Clubs before they used to establish an amount said to be 400K or more. The court would say this is abusive. Now clubs have started to cover in their backs by auditing all their expenses. I think the question they said is why Spanish teams are auditing their expenses now. So far, I'm trying to think what the question is here. Just to clarify, my point is that young players' salaries at age 16 may be low when considering the maximum amount for a buyout clause. But the truth is that perhaps after 3 years, the same player may be earning loads of money, and the buyout clause wasn't fair at all. Especially as said. Did you want to take that, Ricardo?
Yeah, I think at the point from Marta. I mean, because as said, I mean, under the Spanish system, the judge has the right to moderate the amount of the buyout clause. So I think that clubs, they are auditing the investment they're making on young players, educational, training facilities, etc. So they're auditing these expenses and these investments. So in order to have an argument that in case that football player try to make that amount, that buyout clause null and void, or to ask to the judge to moderate the clause just for the team to explain to the judge the rationale behind that amount. So I think that's the rationale behind this work, which is being made by in particular by the big teams, not big teams, but most of the football clubs that are playing in La Liga, in the first and second division.
Well, so it would seem sensible, really. Yeah. Anyway,
I just wanted to add an American perspective here. The bottom line is, if elite players are going to be trained as teenagers to identify the handful of teenagers who are capable of playing professional sport at the highest level, someone has to pay for that training. And traditionally, it has been smaller clubs or larger club academies, etc., and they have been protected by buyout clauses and the FIFA rules. In the United States, we don't have that system. We have, it's a stereotype, a privatized system where wealthy parents pay coaches to train their athletes so that they can go on to play college or professional sport. In all sports, basically, but football. The result in baseball has been severe inequality, a dramatic decline in African American and Latino participation. There are more Mexicans playing Major League Baseball than there are Mexican Americans playing Major League Baseball, because Mexico still has an infrastructure for training poor kids. We don't in the United States. So as Europe continues to think about this, I think it's important to focus on some of the abuses of the youth training system, excessive buyout clauses, etc. But I think it's very important for Europeans to retain a model where the football clubs have a sufficient incentive that they will continue to train kids who cannot afford to pay coaches themselves to get the training, and so that all kids have an opportunity, if they're good enough, to play at the highest level.
Sure. Okay. Yeah, I think this is one of the what we're talking about here, and this is the crux of the issue that we're talking about. Someone just raised the point around sovereignty, and I'll come on to the question in a minute, but this is the difficult balance, right? When you're trying to be an international sports governing body, a federation, and you're trying to develop the sport, you have to bear in mind all these factors, and you might have the wrong effect. If you introduce the wrong type of regulation, you may create indirect incentive for others to do other things. Now we've got Diego Ocadis. I think that's correct. Have all these people and just go around offending people globally by saying their names wrong. Diego's asked, talking about a prescription, which laws does apply FIFA regulation or domestic law? For example, in Mexico, does domestic law establish a period of 1 month to sue your boss if he's fired, and FIFA regulation establish a period of 2 years? So again, this is tension between the domestic, whatever's happening in domestic laws. And I know, for example, from one of our colleagues in Spain, Josep Bandelos talks about this a lot, particularly within Eastern Europe, that sometimes when you have this tension between the FIFA regulations and domestic law, and the FIFA regulations maybe, and even the national associations maybe, let's say, even the arbitration or dispute resolution mechanism alternatives may not be the most efficient. You can try and have to go to domestic courts, and the domestic courts don't really recognize, depending on where you're at, may not recognize FIFA regulations. They may say that domestic laws are actually superior to FIFA regulations. Who wants to take that one? It's a bit of a tricky one, I think.
One of the novel issues I'm trying to raise in my research is the idea that unduly weak member state domestic remedies for breach of contract could itself impair the free movement of workers. I think it's fairly well established in European football that there are higher risks when you bring in a player who has not played in your league, in your system, from another country. So to use an example, if there were no FIFA rules and we only use domestic law, and Belgian law, employment law, provides virtually no remedy for the club. Now, if you're Anderlecht, are you more likely to sign a established mediocre Belgian player where you know what you're getting, or are you willing to take a risk on a young Greek player? And with the FIFA rules, you might be willing to sign a Greek player to a 4-year contract, knowing that if the player really takes off, you've gotten the benefit of the investment in this great undervalued player. If you are solely reliant on Belgian domestic law, you are going to sign the Belgian player. So if we didn't have the FIFA rules, would a Greek player have a claim under European law that the Belgians' refusal, the Greek player says, I am willing to go to Anderlecht. I would love to go there. I would love to get a high salary. I'm happy to sign a 4-year contract. I'm happy to be bound with a very high buyout clause in the contract. Belgian law won't let me. As a result, Anderlecht is going to hire some mediocre Belgian player instead of me. This impairs my right to a free movement in Europe. And this is not a question that I can find that any of the European courts have addressed yet. but I think it's an interesting sidelight that goes into the question of why FIFA should be allowed to have special rules beyond domestic contract law.
Interesting. Daniel, did you want to pick up on that, or Ricardo?
Nothing from my side. I mean, that's quite interesting paradox, to be fair.
Yeah, exactly. I know. I'm kind of lost. Like the challenge becomes, as I said, if you're trying to create, and I always think from an antitrust perspective, I am very interested in this, and I think that for example, it raises questions around ownership of football clubs, which again, the FIFA regulations, the updated, let's say, regulations that are coming out on agents and loans, and the reforms that are potentially coming through in September, October, or this could be proposed, may address some of these issues. But I think in a more complex, football's become such a more complex global business and global market. It becomes very, very difficult when you have this tension between, as you were saying, the European Union laws that apply, domestic laws, and then international laws. It would seem to me that there needs to be some minimum standard. What that is and how you negotiate that seems to be an enviable task for the guys at FIFA, I think. But they're always in, Stephen, one other thing is that they're always in dialogue, and I think that'd be interesting to do some analysis on, but they're always in dialogue with the European Commission on how their rules are going to be interpreted. And obviously we saw the FIFA complaint that was filed that then caused a lot of the negotiations that are taking place at this moment in time. So it's not to say there's no appetite to look at this from the European Commission. It's just a case of whether or not someone's going to file a complaint, or if there's something that could be addressed through negotiations. Next up we have so by the way, if you do want to actually ask, so I can actually come to Serhat. I'm going to turn your mic on. So Serhat Yilmaz from Loughborough University, I think Dr. Serhat Yilmaz to be correct, who is a sports or academic in himself. Serhat, I just turned your microphone on. Would you like to ask your question?
Yeah, hi guys. Can you hear me?
Yes, we can.
Yes, we can.
Sorry, I'm new to this whole webinar. Yeah, I'm really enjoying this. It's great. So my question is to Ricardo, and it's in relation to, this buyout clause dispute between Barcelona and Atletico Madrid in relation to Griezmann transfer. So it seems quite technical, because the argument put forward by Atletico Madrid is that the value should be higher. So can you explain about that and the technical side of it in relation to Stan Show, please? Sorry, guys.
Yeah, I mean, what I can just tell you what I read from the press, from the media. But I mean, basically, buyout clause, Griezmann's buyout clause in his contract with Atletico Madrid was a certain amount, 200 million euros. Okay, but at certain moment in time, in 1st of July 2019, the buyout clause, the amount was reduced automatically to 100 million euros. Okay, so basically Barcelona paid the buyout clause. Well, not Barcelona, sorry, Griezmann. He paid the buyout clause. Okay, he went to La Liga headquarters and he paid it. And now the argument of Atletico Madrid is they are claiming the 200 million euros under the rationale that the negotiations between Barcelona and Griezmann started prior the 1st of July. And because this negotiation started prior the 1st of July, Griezmann had to pay 200 million euros. Obviously, this is on the media and on the press. We don't know what will happen. We don't know so far if Atletico Madrid will take Barcelona and Griezmann to the courts. Nothing has been said so far. It's just rumors, and we will see how it comes. But due to the fact that it was provided in the agreement that two different amounts for the buyout clause depending on the period of time, obviously Atletico Madrid is taking the opportunity as they're defending their interest to get more money. But I guess that the lawyers of Atletico Madrid and Barcelona and external counsel that has analyzed this wording. So we don't know what happened, but the explanation to your question is that there was a different amount depending on the time that the buyout clause was executed.
If I could just, Sean, if I could just jump in very quickly to offer how this dispute would come out completely differently in the United States. So in the first place, you wouldn't go to court because the clubs in every league have agreed that any dispute between the clubs must be submitted for arbitration by the commissioner. So if the La Liga had NBA rules, Atletico Madrid would file a complaint and the arbitrator would be Javier Tebas. The second point is that if, in fact, there was any negotiation between Barcelona and the player, and it was not authorized by the contract, the senior officials of Barcelona would likely be suspended for an entire year for, quote, tampering, end quote, with a player. So the idea that the player could walk in and have all these negotiations in advance wouldn't happen in the United States because we have these super strong rules against clubs discussing with the player or the player's agent what might happen at the extension of the contract. In effect, in the United States, a player's contract gives the club two exclusive rights. They have the exclusive rights during the term of the contract to the player's services, and they also have the exclusive negotiating rights with the player until the expiration of the contract.
And so, isn't that a Kwari Leonard? Is that, I'm saying his name right? Kwari?
Yeah.
I'm saying his name. Yeah. That's the whole point with him. He was saying that, you know, if they come back to the Raptors, come back to me, yeah, we have a great offer. I'll consider, you know, really interesting. Raises some, there's a bunch of different questions that arise from that. Thank you, sir, for that question. I'm going to turn your mic off now. One comes in like, how the hell did he finance that? And who's financing that? Which, Daniel, I know third-party ownership is one of your pet topics, but you know, where people are getting finance from to fund their own buyout clauses, I think is an interesting question. I think from a regulatory standpoint, probably partly outside the scope of this. We've got. Daniel, did you want to add anything? I'm not sure. Are you guys all right on time? I know that we're now, people, believe it or not, are still tuned in. But the
I need to jump off in about 5 minutes, right? But yeah.
Right. Okay. Let's go quickly then.
I was from Ricardo. Just I thought it was really interesting, which is it seems like the latest situation with Griezmann is that Atletico have asked La Liga not to register Griezmann, which I find just as an interesting aside, whereby regardless of whether the buyout number is one number or the other, whether there's actually an interim element to all of this, which is whether La Liga will agree to register pending the outcome of a dispute over the exact amount owing. I presume that would probably have to be the case rather than awaiting what the amount is owing before the transfer and the registration can actually happen. And I just thought that was quite an interesting element that we saw in the last couple of days too.
Yeah, it's a good point. My opinion is, I mean, I have no doubt that La Liga will register Griezmann. Will register Griezmann because they have copy of the contract, because the contract has to be registered with La Liga, and in the contract it is stated that as of 1st of July it's 100 million euros. So they will not take part on either it's 100 or 200. They will let Atletico de Madrid to go to the courts or to the Spanish sports jurisdiction. But they will just. I mean, I think that La Liga in that case, his role is not to moderate, not to judge, but just to register the player.
So is it correct, Ricardo, is it a correct assessment that there's often a lot of rhetoric and politics involved in public statements, particularly happens in football generally, but particularly in Spain? So when the Neymar case was going on, when he was moving to PSG, there was a lot of things said in the press, but they weren't actually going to bear, and they weren't actually going to come into reality, nor did they have any grounding necessarily on what the regulatory standpoint were. They were just provocative statements to enhance a negotiating position.
Yes. Bruce.
Okay, great. So, well, Daniel and Ricardo, I need to go quickly. Alexander, I'm going to turn. Alexander Kopos from ISDE is going to ask a question. We'll take your question, then we'll take, we'll just take your question, and then I've got 2 shorter questions as well. We'll take them all at 3 times, and then we'll address all of them, and then we'll have to wrap up, sadly. It seems like, obviously, we try to cover a lot within this session, so let's give it a go. So I'm going to unmute you. Alexander, you just need to unmute your mic if you want to ask the question. If not, it doesn't work, I'll give you a few seconds to try that, sort that out. If it doesn't work, I shall just, I think you sent your question. Okay, I can't get it to work. Just for time, I'm going to ask it. So you said, interestingly, actually, I know Dr. Sahar Yilmaz is working on this. The Guardian Toolkit for Child Protection came out last week, I think it was. Will the protection of minors players before and when signing a contract, will it be followed by some changes to, do you think it'll be followed by changes to the regulation on the status of transfer of players? It seemed to me that, I'm not sure if anyone else wants to take that, but it seemed to me that that's absolutely informing what's taking place at the moment, that the safeguarding issues are, and child protection is changing how minor contracts are being approached and the signing of that. Would you agree? Nod? No?
Yeah, just very briefly, I mean, it's obviously a very hot topic. There have been cases in the UK, especially, where agents have been sanctioned for intentionally or otherwise approaching either under 16 players or players for the year of their 16th birthday, and there's pretty stringent regulations in the UK to prohibit that type of activity, and then to regulate that activity to ensure that people have advanced police checks, basically, to ensure that that additional duty of care and that training is actually given correctly. So yeah, there's also another element to all of this, which is how then agents will approach minors as defined between 16 and 18 years old. And now the enhanced rule by the FA, at least, is that an agent has to actually go directly to the guardian / parent before they can actually directly go to the player for consent. And that, I think that, that's just an additional safeguarding, way.
Well, there was also a point that I know that is being looked at this moment with UNICEF and with UEFA, with the research team that Sir had and the guys at Loughborough and other people are involved with at the moment, because there's this tension with transfer of minors as well. But given in any other sector, you can move freely. If you're a great musician, if you're a great actor, artist, you can move all around the world pretty much if someone's willing to pay you enough. Whereas in football, that's not there, and it's been there because of justified in the sense protecting the young individual, but sometimes I think it's now recognised that it's not always achieving that objective. So that is currently being looked at, and there should be videos up from the football law conference that we did in May that should be on the website in the next couple of weeks. And also I think it will be part of further analysis and from FIFA and us.
Yeah, let me just note on that very point, when we analogize it to the entertainment industry, I would ask listeners to think about these demographics of the entertainment industry and how much more diverse the football industry is. And one of the reasons is that you're free to go, but your basic training as a young actor is usually at your own expense. And the whole issue of being free to move is because the Royal Academy of Dramatic Arts does not provide you with a salary and free training in return for the fact that you'll perform at the Old Vic for 3 years so they can recoup their investment. So I think that's the trade-off we have to think about when we compare various industries.
Yeah. So last 2 questions, I'll do both at the same time just because I can see Daniel starting to I know that, so I'm really pushing this 5 minutes. Victor Ocando, so if we don't have time to answer, then so be it. But anyway, just thanks, Victor Ocando. I would like to know the opinion of Stephen about the MLS Players Association position to call training compensation solidarity payments a tax, and his perspective based on the Fraser Decree of the US Soccer Federation. Would that be a solution? Question mark. I don't know why I said question mark. I'm so used to doing dictation. Stephen, hold that thought for a second, just in case Daniel needs to drop off. Tayo Ongalui, my question as it relates to representation of players during a transfer and what the latest FIFA rule is. Can an agent from another country represent a player in a transfer negotiation in another country? If he can, what conditions must he comply with? I think it depends on national association rules, basically.
Yes, it depends on national association rules.
Yeah, we got stuff on that on LawInSport. You should check it out. It's a great website. Stephen, would you like to finally? I'm sorry for the other people who've asked questions. Daniel, you can head off. Thanks so much. Stephen, did you just want to take that point around Major League Soccer, because it's been really interesting, because they were anti-training compensation solidarity payments until they became exporters, and now they're very pro training compensation solidarity payments.
So the MLS has changed its opinion. There's a bunch of complicated rules with consent decrees, and their ongoing labor negotiations with the players union in that regard. They sort of, you can't have it both ways. You either have to pay compensation or you don't pay compensation. And the other question is, MLS has shown no interest in compensation within the MLS. So they're sort of still sorting through that. In terms of the Fraser decision, this is a US court decision that held that the competition law did not prohibit the MLS labor agreements, finding that the top players in the US had the choice to play in Europe or Mexico, and the bottom players could play in a lower tier league that is not part of the MLS structure. So it's a one league decision as opposed to a FIFA decision, and it raises some different issues.
Sorry, this is my office telling me the lights went out in terms of the time. That's like a great timing. Thank you very much for that. So I think we had a couple other questions. I'm really sorry, we really are out of time. I think we'll do joking around, like a virtual round of applause for our speakers. I know Daniel had to leave. Thank you very much for this, Stephen. Thanks for being the provocateur of this debate and getting the ball rolling on this. As I always say to people, if you enjoy what we do, if you enjoy these discussions, please do tell people. You can share obviously on Twitter or LinkedIn, whatever. Please do tell people that you enjoyed it, what you learned from it. We'd appreciate any feedback that you have, positive or negative for that matter, things we can improve on. If there are topics that you would like us to cover in the future, because we're having an internal debate at the moment, if we do 2 or 3 of these a week. Next week we've got one with Carlos Snyder from FIFA, head of discipline at FIFA, going through the changes to the disciplinary code, which is going to be really helpful and useful in taking question and answers. But if you do enjoy these and you would like to see more of them, please email your suggestions to info@LawInSport. This will be recorded now and should be up online in the next couple of hours on the GoToWebinar sort of page, and then we'll put it onto YouTube and onto lawinsport.com. Other than that, thank you again to Ricardo, Stephen, and Daniel who had to leave. Thank you guys, for those of you who stay on for longer than an hour, and for your questions. That's fantastic. It means that we're actually helping people if we're answering their questions. So thanks for sharing your knowledge and wisdom. Really appreciate it. Have a great evening. And Tolo said virtually clapping. Thank you. All the best, guys. Thank you very much. Bye.
Thank you. It's been a pleasure. Thank you. Bye bye, Stephen. Bye bye, Sean.
Talk soon.
Talk to you soon. Cheers.